Hello, everyone. I'm Richard Fink, a lawyer in the province of Ontario who specializes in workers' compensation.
Oh, that's
And
me. Hello, everyone. My name is Paul Taylor. I'm a paralegal I spend a great deal of time helping injured workers deal with the Workplace Safety Insurance Board and Tribunal. I also have a specialization in human and charter rights law. I enjoy it. If you want to reach out to either one of us or be part of our podcast, if you're an expert or specializing in anything, send us an email to the links below.
today's our first podcast, and today and every week we're going to be discussing some of the poor treatment of injured workers by the Workplace Safety and Insurance Board and what can be done about it.
This week's topic, we're going to talk about forced return to work. Let me explain what I mean by this forced return to work. In the Workplace Safety Insurance Act, it says that the board can tell you to go back to work if the work is safe and suitable. And this is where the issue becomes very technical term subjective, but it isn't. It's where the board case manager will say, often you'll hear, I think it's good for you to do the work, or I think it's okay. And generally I've noticed they never say the word safe and suitable, because if they did, the worker would treat it as a red flag. And you're going to hear some stories from myself and from Richard, who's been around a little bit, to talk about some of the really wild decisions and cases that they've had. And I'm going to go to Richard first. You can talk about some of those cases.
Well, there's two that hit me when I start to think about this topic, and one of them was a worker had a severe eye injury and the employer offered him work, but the employer's environment was sawing wood and it was very dusty. And he was forced to return to work on the basis that if he didn't return to work, he would not receive any benefits, even though there was dust in the environment, which would get in his eye and make the eye injury more painful. So the WSIB cut him off benefits. And that's a key issue, which is it's not like you can appeal and stay on benefits when you appeal. If you don't do as the WSIB commands, then you're off benefits. So he appealed that, and 2 years later, they reestablished his benefits based on that going back to a dusty environment with an eye injury is not a great idea.
Yeah, just to add to that about the benefits, Alberta, interestingly enough, is the only province in Canada that actually has a program of interim benefits that if the injured worker is appealing a decision, then they can apply for interim benefits. It's not a perfect system. It was a system created under the NDP, under I think it was Rachel Notley. And the thing that I like about it is when an injured worker is waiting, what you'll hear, and I've heard this from the Minister of Labor, is, well, what do I do in the meantime? How do I pay my rent, pay my bills? Or do I just starve? And the common response is, well, go on welfare. But welfare is taxpayer money, and that doesn't sit right with me. And I'm sure it doesn't with you, Richard. And that's why in Alberta they brought out this program. And I think it's a fair program. The only problem is now it's become like Ontario, where it's literally an impossible hurdle to get anything, or they deem the worker and say, well, we think you can do this and so forth. But still, it's kind of a partial answer to the forced return to work thing. It really identifies that forced part, that even if I know it's unsafe to do the work and unsuitable, and even if I'm going to get re-injured or maybe even die as a result, I have to do the work, because if I don't, I will starve. And this is something the boards know and they take advantage of.
This program of compelling workers to return to work and making it a priority is about 20 years old. It was not as big a deal 20 years ago, and it's a way to push employers and injured workers to save the WSIB money, and at the end of the day, save employers money. So what you'll see is a lot of employers taking workers back to work that's useless, or taking workers back to work that's demeaning. My favorite one is one where the worker was a machine operator and he was sent to clean toilets as his return to work, which is pretty demeaning. And the appeals tribunal, which is the top level of appeal, has said carrying around a sign on the sidewalk to convince people to go into your employer's premises to buy something is demeaning, and you don't have to do it. But if you're assigned to clean toilets, you do have to do it. So you can imagine the anxiety that it produces to go from machine operator to toilet cleaner. The case, one of the cases that I was looking at recently was the worker was asked to travel 3 hours to work because his construction employer was going to put him in another city. So that's a 3 hour one-way drive, whereas previously, before the accident, it was taking him about a half an hour to get to work. And the appeals tribunal has made a ruling that maximum time for communication to your employer or to getting to work is an hour, 20 minutes, and not a minute more. So if the employer is pushing you saying, okay, I got a job for you, you live in Hamilton, I've got a job for you in Oshawa, no, that's inappropriate.
Yeah, see, the other thing that comes into mind as soon as when you're talking about the demeaning part of the return to work, and then also the change in the workplace, is what flags in my mind is the Human Rights Code and the Human Rights Commission's guideline on persons accommodating persons with disabilities. It's an amazing guide. I wouldn't say well, it's a policy, but I would say it's a very powerful one because every time they talk about process or something, they're referencing cases like the Supreme Court of Canada, Court of Appeal. So it's a powerful resource for representatives and even injured workers. Unfortunately, at times in my own personal experience in dealing with my own case and individuals I represent, seemingly the board and tribunal doesn't recognize it. So that's another issue. But getting back to the demeaning part, it's very clear, and the Supreme Court has said that if the work is seen to be demeaning to the individual, it's not accommodating the person. See, what you were talking about is return to work in the WSIB and WSIAT system. What I'm talking about is accommodating a person with a disability. Now, many would say, okay, well, what's a disability? What's a work injury? What's fascinating, Richard, is in Ontario, it's, as far as I know, it's the only province where the Human Rights Code actually defines a work injury where somebody that is claimed whether it's been accepted or not by the WSIB for workers' compensation benefits. So, in other words, if you've made a claim, and even if the claim was denied, you still have a disability. So, I've heard of workers where they made a claim for workers' comp, it was denied by the WSIB, and then they go to the employer, and the employer says, no, we don't have to accommodate anything. Yes, they do, because it's still a disability. And the same thing applies to when the board is assessing, because oftentimes, and this is where it gets complicated, because who is saying the work is safe and suitable? Is it the employer saying, well, this is what we're offering you, and it's a reasonable accommodation, is what I hear now in the human rights arena. And and then it's not usually what I notice is the employers are smart. They step back and they let the case manager make the decision and say, well, as far as I'm concerned, it's suitable and it's safe, or the return to work specialist. And oftentimes I want to say to them, well, do you have any experience in medical? Do you have any experience in law, human rights, or anything? Because they're making these determinations and they're not considering the Human Rights Code and the guide and dealing with things like the work has to be comparable to the other person's work, making them do further or driving further. What's the favorite one, Richard, about driving? Oftentimes, I've argued with case managers about the worker can't drive their car because of the medication they're on. And the case manager will go, well, as far as we're concerned, he can drive because the doctor hasn't revoked their license. And I'm like, that's an idiotic argument because I can go to the bar tonight, because it's my birthday, by the way, and get hammered, not drive, take a cab home, but then the next day, after I'm sobered up completely, I can drive. You know what I'm saying? So there's that. And they don't see that concept of saying with a work injury with medication impairing effects, people can withdraw themselves and are legally obligated to under the law from operating a vehicle. They leave it to the doctor to say they cannot drive. And that's not, in my point, a legal thing. And I go so far as to say is that if a worker's doing like forklift or a safety sensitive position and we're dealing with medication side effects, the board has a legal obligation under the criminal code to comply. Like if you're operating a vehicle under medications and the case manager says you have to, and you're a starve out technique, that's intimidation and harassment. And the worker feels compelled to do it. I've done it. I had to. Many workers do. And that's something that the board isn't recognizing. And I think you've experienced this at the tribunal where the WSIAT will say, well, it's the worker's responsibility to find alternative medications, that don't have any impairing effects. And I've yet to find any medication, even aspirin. You know what I mean?
Well, let me deal with a slightly lighter note, but on this question of medication and driving to work and return to work, which is we have a case where the worker couldn't drive because his arms weren't working, and his employer said, "All right, we'll give you an Uber and get you to work in an Uber." And one day the Uber driver reported that the worker was doing sexually inappropriate things in the Uber, and the employer terminated the worker from employment based on what the worker was doing in the Uber, which is somewhat interesting given you're not really in the course of work yet when you get into an Uber. And the second thing is the Uber driver would not testify publicly about what happened, just reported it to their Uber service coordinator. And they have video in the Uber car, and they wouldn't release that either. So the worker's cut off from his modified job, and all the parties are fairly pissed off, so to speak. And I think the problem in these types of cases is the WSIB needs to like assist the parties, like be an assistance as opposed to being a determinative function. So take the fellow who's in the Uber car. I mean, he's on all kinds of medications. If the allegations are correct, or even assume they're correct, he needs assistance to get it together to act appropriately, not to be cut off benefits and not to be thrown in the trash heap.
I mean, that case raises some interesting legal perspectives because from a legal mind, like from the average person, they'd say throw him in jail and everything else, and many would agree. The only problem is you have to actually have evidence to support the claim. And that comes from the employer side, or even if it went to the Crown Prosecutor's office, if it became criminal. And if the driver's not willing to testify and the video isn't available, it creates chaos in the complaint. So the employer can't really take any action because now they don't have any proof, and it really puts it difficult for the employer because if this falls into the workplace and there's coworkers, that's workplace toxicity and harassment on the employer. Other workers shouldn't be exposed to that if that is what's happening. But then we don't know. I'm not a doctor or anything, so I don't know if it's caused by medication side effects or anything. I don't know. I just know I can control myself as far as I know. But, the world, as you know, and you know better than I, because I think you're a little bit ahead of me, is it's a really interesting place. And I can thankfully say I've practiced in criminal law, but thank God I don't have to deal with these big cases, the horrid cases of society. But it is an interesting one. What did they finally decide to do, Richard? Do you know?
It's the employer cut the worker off, the WSIB cut the worker off. So the worker's appealing, and the employer is fighting with its union to terminate the worker. So it's a two system prong attack. So let me just conclude with one more case that raises these types of questions Paul's mentioned. And I might say I'm farther along. You can tell by how much hair I have compared to Paul. And that one is that the worker works for his father and his grandmother in the business. And the father is really cheesed off with his son because he says his son's not carrying his weight. So the son, they have constant fighting over their job responsibilities. And then the son has a severe arm injury. And the WSIB says, your father's got suitable modified duties for you, get back to work. And the son is saying, I don't want to work in this hostile work environment. The father's constantly demeaning me. So is my grandmother. I don't want to be there. And goes through the system, which takes 2 or 3 years. Finally, the appeals tribunal rules years later, you don't have to return. But the WSIB itself should be the one to intervene and get these things straightened out one way or the other, not forcing people to go on for years. So, with that, we're going to conclude today's podcast. As I say, we'll have email addresses up. Give us your comments. If you'd like to attend and be on our podcast, please send us an email. We'd be happy to have you. And next week, again, we'll be on with a new topic. Thanks.
Thank you.